On behalf of the Environmental Law and Energy Program and the Animal Legal Education Initiative, I'm delighted to welcome you to this wonderful presentation that we're going to have today. Dr. Carolina Maciel will be speaking on the topic of animal protection measures and their effects on international trade. The title of her talk is Advocating for Animal Protection in an Interconnected Global Economy. So just a little bit about Dr. Maciel. She's an experienced attorney and advocate of animal law with specialties in the mandate and activities of the World Organization for Animal Health, the agreements administered by the World Trade Organization, the regulatory structure of Brazil and the European Union. She's currently the senior advisor in international trade law and policy for the World Federation of Animals. She's the chair of the America Regional Working Group of the International Coalition for Animal Welfare, an adjunct faculty member for Vermont Law School in their online learning program. She's also a member of the Brazilian Bar Association, Women Trade, Inside Trade, and Society International Economic Law. That's just a snapshot. There's more that I could say, but I don't want to take time away from her wonderful talk. So please help me welcome Dr. Maciel.
Thank you very much for being here, for choosing to be here. It's my first visit to the University of George Washington, and it's amazing to see that much crowd interested in this topic. So it's a good sign. Thank you for having me here. So what I'll be talking with you today is about advocating for animal protection in an increasing interconnected global economy. And I will talk about some of the constraints that being this interconnected economy provides or impacts our animal protection advocacy. But I also would like to say from the beginning that even though I will bring some constraints, by no means the takeaway message is negative, will be a positive. I'm giving a little spoiler about that. But also want to emphasize that I could also, perhaps in another opportunity, talking how the international trade and this economy provides a positive impact. So again, the focus might be some of the constraint, but there's so much more we can talk about that. So when we are advocating and we want to take the animals out of those cruel practices, we go there and start asking for a policy change so animals can have a life worth living. And when governments hear us, and there's several options for a policy to make those things happen. It might be a labeling scheme, it might be some fiscal incentives, might be some legislation set down requirements for the production of some of those products, or even some requirements for the sale of those products. So there's a lot of options out there. And what we see nowadays that the decision-making process takes into account not only economic factors, but legal factors. So basically the government will think in the following, okay, should those policies be mostly focused on what is taking place here at my jurisdiction, because that's where I have legal jurisdiction, but also we need to take into consideration that because we are in a global economy, the products that are sold here come from elsewhere, the products that we produce here, we go elsewhere. So we need to take that into consideration, not only in terms of the economic impact that it takes, but also about the legal challenges that it might impose when we think about that. And probably much of you in this room have known more about the Prop 12 and the Supreme Court's challenges that is out there. But that is specifically what it raises when we try to make sure that the products, we take the economic and legal consideration in place. And then we see, for instance, when California adopted this policy, not only regulating the production in the territory, but the sale, the marketing. And then we have this knowledge about the extraterritorial effect, about excessive burden, legitimate local interest. And I have a good and a bad news. The bad news is this kind of discussion is not only in terms of the state legislation within the US. I have been working in a similar case in Brazil when we try to defend a state ban on animal testing. And it also takes place at the global level. Because again, let's say, and hopefully that legislation will be enforced. US is also part of the WTO, and some of this discussion will take place. Again, that's the bad news. The good news is, I think, and what I will try to show to you is that over the years, the jurisprudence have evolved in a way that nowadays it brings a more solid and a clear guidance on how a state can defend such legislation. So what is the WTO? The WTO is an organization located in Geneva with a membership of 164 countries. Basically, 98% of the global trade takes place within these rules. The WTO has basically three functions: to administrate these trade agreements, to settle disputes when one country thinks their right has been violated, that one of the provisions of these agreements haven't been observed. And the WTO also offers a space for countries to continue negotiation for new agreements. And I would like to emphasize, before we get into each of those functions, what I find very interesting about the WTO is that it's both. It's a very new organization. It was founded in 1995. That is just yesterday, honestly, in terms of international policy making and international organization, if you compare, for instance, with the UN, United Nations. So it's a very young organization, and that has an impact because we all were learning how to deal with this new organization. But at the same time, it has an old baggage, let's say, because the WTO comes, we can think about the World War II when the economies were destroyed and, well, not whole economies, but the war in Europe, the way it left economy, there is a need to build again. And there was also a are you all still with me? Okay, the microphone was changed. I hope it's still okay for everyone in the room and online. Okay. So in 1947, 22 countries came together and signed this agreement, the General Agreement on Tariffs and Trade. And the whole point of this agreement was to build a regulatory framework for the behavior of countries when they are exchanging goods. And we'll see in the preamble of this agreement that in the field of trade and economic, there was the idea of expanding the production and exchange of goods, the need to reduce tariffs, because an important product could even have a tariffs of over 2,000% of an increase when they cross a border, and the elimination of discriminatory treatment. Why was that so important? Again, they want to make sure that the post-war world wouldn't take with them this, you have been my ally, you have been my enemy, I'm going to do a different policy for you, I will facilitate. So the idea of the discrimination, eliminate the discriminatory treatment, was to make sure that the goods would flow regardless of the country of origin. And this pretty much remains a cornerstone, and we will learn about this a little bit more. But at the same time, the notion of discrimination, how you interpret it, has also posed some challenges in terms of advocating for animal protection. So the continuum of the GATT, the countries engage in more round of negotiations. They wanted to build more rules. So you see here that over the years, more countries joined, more disciplines, and that ends up with the Uruguay round that ended in 1994, and that's what they gave the origin of the WTO. So it was in 1995 that the WTO opened its door. And within the agreement of the WTO, you have the GATT. That's why I say it takes this old luggage with it, because the GATT was already in place and it's incorporated with small changes within this new framework. But I wanted to highlight the following. It takes time to change the switch inside each one's head in terms of this new organization. Because you see now here the preamble, similar preamble. You see that the idea of expanding the production, elimination of the discriminatory treatment is still much there. But there is one sentence here that I want to highlight. And it's very important to highlight and to remind trade officials that the new legal framework for international trade also has to be in accordance with the objective of sustainable development, seeking both to protect and preserve the environment. And I must say that for a while, a lot of people didn't realize. I think they were too busy getting to know, again, the WTO as a whole, and they kind of forgot. But I'm very happy to say that this year, we will get back there again, but this year the WTO finalized its first new trade agreement where sustainability is at the core of this new agreement, is the one about curbing down fishery subsidies that helps, unfortunately, illegal fishing and sustainable fishing. So it is the very first sustainable, it took almost 30 years, but we are getting there. Again, my message here is positive. So the other thing that I wanted to call, and that was when at the beginning, when there was this shift from the GATT system to the WTO, and we see here now the WTO brings new disciplines. So you have the GATT agreement, but you have a lot of other specialized agreements and servicing. There's a lot of new content here. We don't need to go down here, but I want to emphasize two things. One is that in addition to have new disciplines, the new mechanism of dispute settlement also make governments a little bit more concerned with this new system. In the past of the GATT, when there was a trade dispute between countries and the adjudicatory body would look at the case, and the final report needed to be approved by all the contracting members, including the country that has lost. And there was not really willing to support that report. Nowadays, under the WTO, there is a reverse consensus. So a report, a decision will not be implemented unless all of the members decided not to approve the report, including the winning part, which of course have the interest to have that report published. And I'm telling, and just out of curiosity, the number of cases that have been adjudicated under the GATT system and the WTO, you see that in a half of the period, there's the double of the case. And I'm telling you all about this because these two new features, the additional content and the new system, have caused what has been called as a regulatory chilling effect on governments in several policy fields, but specifically on animal protection. And two cases illustrate that. The first one was a discussion that was taking place in the European Union to ban the use of animal testing. And that regulatory framework have originally been adopted in 1976, if I'm not mistaken, and was aiming to be enforced in 1998. So just a few years after the WTO system was incorporated. So they decided to, let's put a pause for a while. And then there was another postponement. So this regulatory framework was postponed several times. And the official explanation for the government to take that decision was the need to see alternative methods, but also, and they highlighted that, it was the need to understand the interpretation of the WTO provisions, especially the idea of like products, which remain a very controversial concept within the WTO, and the use of the Article 20, which is a defense. So for you to understand where this was coming from, think, for instance, of a facial cream. When you see this facial cream, by looking at this without the labeling, can you see if that cream has been tested or not tested on animals? No, you can't. There is no physical difference on the end product. And that's how some people interpret the notion of like products. If there is no difference on the end products, therefore they are the same products. And within the WTO, as we'll see, you cannot discriminate the same products. And the Article 20, we'll get there later, is where countries can deviate from this overall rule. The other example of the effect of the WTO on the policy making for animal protection relates to laying hens. So again, there was a regulatory framework establishing minimum standards for the protection of laying hens in the European Union. If I'm not mistaken, it was 1999 that was adopted. And the original idea was for these requirements to be required for local production, but also for the imported products. And once again, that was not the case. The decision was to narrow for only domestic production because they wanted to see how the negotiations would take place at the WTO, whether or not there would be a consensus on how this new regulatory framework would apply for the WTO. That has been said about this regulatory chilling. I think the wind is changing. So the regulatory framework for animal testing in Europe has been enforced since 2013. No challenging at the WTO. So what does it say? Well, it says that countries think that is in compliance with the WTO. That's something positive, the fact that no country has challenged this regulatory framework. Another sign that the wind is changing is that perhaps, the European Union is revising its regulatory framework as a whole, and specifically the use of cages. They want to ban completely the use of cages throughout the production, not only for laying hens, but for rabbits and for other animals. And within the parliament discussion and at the commission discussion, they are considering to now have a provision that will impact imported products. So it's not going to be only for, and the only reason they are considered that is once again, because the legal interpretation have evolved. And that's what I will try to show in the next phase, how we go from that thinking of regulatory chilling effect to a more warm, let's say, effect of the winds in terms of this. So back to the three key functions of the WTO. Negotiation, as I just said, that was one of the outcomes the European Union was expecting to get as a positive sign that animal protection was a subject of consensus among the WTO members. So each new negotiation needs to take place. There is a formal launch of a negotiation because governments need mandate from their countries. And in that mandate, it has the role of subjects you're going to be discussing, and you're going to be entering like a more narrow discussion. Then within the WTO, the new round of negotiations called the WOAH round, which was launched in 2001. In the list of topics Unfortunately, animal welfare did not get through. There is a lot of environment. It's a development agenda, but again, unfortunately, that was not really encouraging. That's why the regulatory chilling effect, because the debates were very, very. Most of the countries were not really willing to include animal protection. And I will show some examples here. The European Union have tabled this proposal, say, hey, folks, animal welfare is an increasing concern, and we have this new system in place, and we need to talk about how can we make the provisions seen as legitimate. That suggested did get through. Again, EU tried with another submission, and they say the following, basically, well, having a new agreement would be very good to discuss, to get this greater legal clarity, but also perhaps let's have an open eye for the existing agreements. Let's have an open eye how we interpret the existing legal frameworks, because even though the word animal welfare, the term animal welfare might not be there, there is still legal basis for us to defend the legitimacy of a government restricting trade on the basis of animal welfare concerns. The outcome of these documents, again, they was not well received, and some of the feeling in that room was that the fundamental problem was that it was perceived as EU-centric, and that was too much like a new wave of protectionism. So other countries was not so willing to take. So again, how the wind is changed. I mentioned the agreement on fisheries subsidies. We are far from going down to a new round of negotiation, but at least that agenda is moving. And even though welfare is not at the topic, it's not at the core of the fisheries subsidy, there's definitely going to have some positive outcomes when we stop the illegal overfishing and so on. So now we'll have a look at the next function and how that has impacted the protection of animals. The settlement, one of the disputes, again, it was not within the WTO, was under GATT. The original trade dispute was about a measure adopted by United States on to protect the dolphins. And I don't know how familiar you are with this. We won't have time to cover all the very relevant trade disputes. I remember, as I showed, there was 600 disputes, so I really had to choose just two to speak with you today. But that one really put a wrong tone on how you elaborate. And that was in the GATT. That report was not adopted, but it has been in the mindset of a lot of people say, hey, animal welfare has no space here. Oops. Okay. Gladly, there was other dispute settlements that came across. Some of them we will be discussing, but all of these that I'm listing now have some sort of very positive interpretation in terms of the provisions in the GATT and some of the TBT, which is a different agreement, in terms of the legitimacy of a government to restrict trade on the basis of environmental consideration, and even further in terms of animal welfare consideration. So let's get to what I'm most excited about, is to look at these cases. So for you to be able to follow a little bit, let me just remind some of you about the core provisions of the GATT. Remember, I mentioned about the non-discrimination, and it has two aspects. You have to treat like products from different countries in the same way. So again, you don't treat country A more favorably than country C. You have to have a justification if you want to make such kind of differentiation, because non-discrimination is a cornerstone. Secondly, you should treat a foreigner product no less favorable than you treat your domestic products. They have to have the same treatment once their products cross the border. But that rule is applied to like products. So if we as policymakers and we as trade officials agree that a facial cream, a cosmetic product, or even an egg that comes from a battery cage and an egg that comes from a free range system are not like products, that rule doesn't apply. So we can discriminate. We can have two different regulatory policies for those two products because they will be different. They will be unlike products. The second one, rules that have been in a lot of the debates, it's about the quantitative restriction. There is a prohibition for quantitative restriction, and the issue is because of import and export ban. But remember I mentioned about Article 20. So what is the Article 20? Article 20 is about general exception. So it's the escape valve when a country don't need to follow those rules. When, for instance, there is a necessary, that measure, that policy is necessary to protect public morals, to protect human, animal, plant, life or health, or it's related to conservation of exhaustible natural resource. And we will see that even though these are here and not easy to justify the necessity, but mostly important, it's the notion that when we analyze whether a policy can be justified under the Article 20 is a two-tiers analysis. The first one is whether it falls in one of those categories. And the second one, if they comply with the chapeau, if they comply with the general heading of Article 20, which here's again comes the discrimination. But the discrimination is more about how the measure is applied. So let's see now how it's turned out in a real case. Again, perhaps some of you will know this before you studied that in environmental law courses. Unfortunately, one of the most dangerous things for sea turtle is the practice of shrimp trolling. The way some of the nets operate, the boats operate. Unfortunately, there's a lot of incidental killing of sea turtle. So a group of scientists came together and there was they devised what is called turtle excluder device, which is a way of cutting the shrimp that makes a way for the sea turtle to escape, therefore reducing the number of incidental killing of sea. Originally, that US measure was focused only on boats in US waters, but after a lawsuit, that measure started to be to imported shrimp boats. Well, that didn't make some countries happy because that meant they need to change their practice in the waters or the oceans across the globe just in order to export shrimp to the US. So they immediately filed a case at the WTO. And you can see it was just 1997, just 2 years after this new regulatory framework was put in place. The outcome of the analysis have the panel and the appellate bodies is a two phases analysis. It was that the measure was inconsistent with the WTO. That sparkled a lot of protests on the street. A lot of people now put in their mind the WTO, it's very detrimental. We need to get out of this. However, few people took the time to read through the whole case and see that, in fact, the outcome was not that bad. Because remember I explained how the Article 20 works? So having these US measures to establishing a condition for the entry of the market based on the type of standards utilized was considered legitimate. There was a lot of challenges again. How can we make sure that this letter here, it was sea turtle? There was a lot of this discussion. It's very interesting reading. Was sea turtle a exhaustible natural resource? The complainants would say, no, they are not. So, and you say, yes, they are. Are they extraterritorial effects? Are they not? So the debates were very intense, but the outcome was that the appellate body said, no, that clause here can be applied. A government can raise that claim. What it failed, and the result was the finding was that this was inconsistent, was because of the manner, not the purpose. And that differentiation between something being considered inconsistent on the purpose of the measure and on the manner of the measure is very, very important. So this policy was considered inconsistent because it has discriminated among countries. Some countries have had over 3 years to adapt to the new requirements, whether other countries, including the 3 countries that filed the complaint, had less than 4 months to comply. So you see this difference on how you are treating some countries where the same conditions apply. One you gave 3 years, the other one just 3 months. And that was the type of discrimination that is not allowed. Also was some kind of discussion about the flexibility. Do you want the outcome, which is less killing, less incidental killing of sea turtle, but you can reach that outcome through different standards. So having some, in that case, there was less flexibility on how you can get to the same. And I think this is a piece of the appellate body, and I think it's fabulous, this piece here, because the appellate body wanted to highlight what they were not deciding in this case. So let me read a little bit for you. I know it's boring when someone reads. So I want to underscore that we have not decided this appeal. We have not decided the protection, preservation of the environment is of no significance to members. Clearly it is. We have not decided that sovereign nations that are members of the WO cannot adopt effective measures to protect endangered species. It's clear they can and they should. So unfortunately, that message was lost somewhere because people were so focused on the inconsistent and that they didn't look. But hopefully now you guys will help me spread that piece of information that comes there. So the other very important case, this is more recently case, concern a European measure. Some people find, I'm one of them, that seal hunting is an inhumane practice. It's awful practice. And therefore, the European Union adopted a legislation to prohibit the marketing and importation of seal products, except under 3 conditions. When they're hunted by indigenous communities for marine resource management, and occasional travelers when they pass by and have, for instance, omega-3 pills in their wallet, but it's not for bringing the whole production inside the EU. Well, once again, some countries were not really happy with this new legislation because it means that they had an economic impact. They could not sell more of those products to the European community. So they filed a WTO case that was in 2011. Once again, the outcome was that the measure was inconsistent. But gladly, nowadays, more people were able to read it through the end, and more people are happy with these cases. These cases now show as a great example. So we had here a for more than the idea of public morals, so the necessity clause on public morals have been in place for over 50 years because it was already on the GATT, but very few cases, there was almost no jurisprudence about the use, what public morality means, what can we justify? So there was a lot of question mark, there was a lot of, not a lot because legal scholarship in animal protection is very, in the intersection of animal protection and international trade is still very narrow, but the very few that have been published had already this question mark. Can we justify animal concerns as a public morality? So the fact that this case confirmed and have established this precedent is a milestone. It's very, very important. So that is what is a lot, the wind that's shifting, it's mostly out of this, this case. So you might ask, so what was the inconsistency about? Was again, not the purpose. The purpose was okay to protect animals, was the manner. So the appellate body found that there was that regulatory treatment between commercial and indigenous practice or commercial and management was not really clear why they need to make this differentiation because they impacted countries in a different way. So the European Union, to bring its measure in compliance with the WTO, just needed to work on the exceptions, not on the main goal of the legislation. And here again, just bring one very short paragraph where they say the appellate body is upheld the panel finding that the protection of public morals concerns with regards to animal welfare is an important value of interest. That is so impactful and is changing a lot. But what comes next? And here's again, this new case, this new precedent, it's huge. I don't want to understate the importance of that. However, it doesn't give us a free pass for every single animal protection measures out there. We still need to think, we government and we advocates and we are asking for governments to implement, we still need to take into account the commitments that our governments have under the international trade legal framework. So what I see as coming next, again, is not a free pass for any type of protection, but I do see what I am calling governance reverse shift. I didn't talk much about that, but when that regulatory chilling effect appeared, when we had governments retreating from the policy fields of animal protection, environmental protection, what we saw happening in the side track was an increase of private policy tools. So private standards, a lot of the market tools were entering. What I see now happening is that governments are feeling more confident and that track will continue growing on private standard, but we are seeing now governments stepping back in the policy field and taking action. So you see California taking legislation, there is more states here in the US, there is more, for instance, in Brazil. We saw the announcement of the European Union. So governments are now feeling more confident that they are able to justify their measure. The second thing that I see coming up next, and where I am going to be looking at more over the next months, is the legal status of the World Organization for Animal Health recommendations on animal welfare. So I don't know how familiar we are with this organization. I think we have some minutes left. I think we have more 10 minutes left, so I can quickly give you an overview of the WOAH standards. So the World Organization for Animal Health, which some of you, the acronym nowadays is WOAH, but just last year, it was OAE, in case you are familiar with this organization, but I'm a little bit confused on why I'm calling this. So in May, they changed their logo. This organization have been in place since 1924, and they were created to help coordinate in animal health emergency that was taking place between 3 countries, and there was a risk of disease being spread to other countries. So they wanted to coordinate that response. In 98, that same organization starts to create some recommendations for the veterinary service of all the member countries of this organization to make sure they have a good understanding of best practice for the early detection, report, and control of pathogenic agents. That recommendation began to be published in a book, which nowadays is called the Animal Health Code Book. Interesting, when the WTO became in place, the WTO have what is called in one of the agreements that we didn't have the opportunity to speak today, but it calls about the sanitary measure. It names 3 organizations as the relevant organization to provide recommendation on certain topics related to sanitary measures. And this code became the relevant recommendation for animal health and zoonotic disease, zoonosis disease. In the year 2000, this organization changed its mandate to incorporate animal welfare because there was an understanding among the member countries of this organization, which began with 22 countries and nowadays have 182 member countries. Is a large membership organization. They understand there is an intrinsic link between a health animal and a welfare. So animal health and animal welfare, there is an intrinsic link. So they have to look at this other dimension of the animal's life, which is their welfare. And they also decided to change their mandate because they thought, well, the veterinary service, which is basically the stakeholder they are in more contact with, are the best one in each country to come up with local domestic initiatives to protect the health and the welfare of animals. So the interesting part is now, and just how those standards are implemented. So there is a topic which came from one of the countries or one of the experts. Each of those recommendations have a minimum, a cycle of 2 years review. It are developed originally by a group of experts on the topic from different regions in different sectors. That group that works ad hoc on the first draft, that first draft now goes in this cycle of 2 years review where experts from each country can comment, NGOs can comment through a organization called ICFAW, which is International Coalition for Animal Welfare NGOs. We have other organizations with whom the OIE, oh, sorry, I shouldn't say OIE, OWA, the organizations that the OWA has a membership, a cooperation agreement, also have the opportunity to present. And then when from these comments that are coming from the ground reach a certain level of consensus, that agreement, that draft is presented in the World Assembly, which is the highest decision-making body, and then everyone says we agree or don't agree, and if they agree, then are incorporated in the codes. So up to now, these are all the standards the OWA have implemented. You see there's for beef cattle, dairy cattle, pigs, all on the ground working equids, but you also see for transportation and end of life moments. Here I brought one example of how one of these standard looks like. This is for pig. So it recognizes that it recommends environment enrichment for in pig production. and not any environment. It's put here why certain qualities of this enrichment must take into effect to stimulate the cognition of animals and the natural behavior. It goes on to say and to explain this, how important social interaction for pigs. They're highly intelligent animals. So why the need for these materials to be chewable, manipulated, because they get bored very easily, and out of the boredom is where a lot of the stereotypes come. Anyway, so these are more or less so for you to have a sample of some of these standards, and they put here the animal-based criteria for the implementation. And why am I going to be looking at this? Why I say this is going to be the focus of my next work? Because what is the legal standard of review? I'm concerned about that. Like I'm curious, not concerned, curious. What's going to be the legal review? The WOAH standards are being recognized for the animal health, not yet for the animal welfare. They have been recognized in the SPS agreement, which is a very specialized agreement for sanitary measures, not for the more general agreement, which is the technical barriers to trade. We have some, so my first question is, will there be in a next dispute, will those standards be interpreted as the relevant international standards? And why it's important to have this recognition is because a country that bases its measure on international standard have a presumption of compliance with the WTO. So it's not a free pass because it's a rebuttable presumption, but puts them in a much more comfortable position, say, hey, my import restriction is based on the international standard. So if you want to challenge me, if you want to say that what I'm doing is against the WTO rules, you have the burden of proof, and it's much higher burden of proof because you have complied with the international standard. So that's one of my first questions. Will the WOAH standard be recognized? I think that's, for all the questions that I have, I think that's the easiest ones to say yes. I think they comply with the requirements that the WTO has established as a reference body. I think where we will have different interpretation is for these 3 articles here, what is based on. So previous jurisprudence, we have saw that there is difference whether a standard conforms to, is based on, so all these nuances that lawyers love, and I'm a lawyer, so I'm not criticized, but I know they will bring a lot of challenge. So I think that's where the next discussion will be. Will not be much focused on the Article 20 that we saw on the case of sea turtle and on the case of seal. I think that's where the next discussions will be. So with this, I finish with 2 takeaway messages. One is that animal welfare is not per se incompatible with trade law. And I can't get tired of saying that because unfortunately out there's a lot of people that still repeat this based on that report that was not even adopted from the early US tuna case. But a lot of people unfortunately have this big view, oh, it's inconsistent. So no, it's not. And we have to stop saying that there is obstacles, but countries have been able to justify and remain with it. So that's the first takeaway. And the second takeaway is that, well, again, there's no free pass. So the manner in which a measure is implemented is very important. And once again, if we go back to this previous case, we see it was about how many months you give to the countries, to your trade partner to implement your new requirement. How flexible are you with equivalent measure? So it's not about the purpose anymore, the discussion, the legal discussions now is in the matter of the application. And again, I think when a country will adopt the WOAH standard, they will be in a much more comfortable situation in explain that the manner in which complies, but is not again guarantee, as we all know, the outcome of a legal case, we never know. So with that, I thank you for your attention. It's been very good. Like to see all these eyes, very interested. So I look forward for the questions. Thank you. Yes, please.
Thanks for your presentation. I have a couple questions. First, how did the European Union respond to or react to the WTO finding that's inconsistent with WTO law, the seal case? And then second, the justification for discrimination of unlike products, is that something that you can also bring forward in EU law? I know that they have similar discrimination provisions. But I'm not sure about the justification. I was just wondering if you know.
Okay. Start with your first question. Of course, in a first instance, EU was not happy with the finding of no inconsistent. But the fact that the inconsistent was on the exceptions, not on the purpose, the measure, for them was a winning. So how they reacted, they saw as a win. So they didn't walk there feeling they have lost. I mean, I don't want to put words on the mouth of the EU Trade Commissioner, but what I remember from that time was exactly that. They felt they were winning, but of course they now, and that's normal for any government. It's very hard when you need to reconcile different values or different policy fields, and that was difficult. How? Because they wanted to protect the animals, but they also want to protect the indigenous community. And that was very hard because it was exactly one of these. They needed to make sure it wouldn't, by protecting the EU indigenous community, they would not be discriminating against the indigenous community from other countries which were complying, were under the impression that they have had a discriminatory effect because they could not surprise. So again, not happy that they needed to change, but certainly they felt they walk away as a winner of this case. On the other question, which was about the justification for the like products, I don't know exactly what the provision wants for the EU regulation, but within the WTO regulation, the alike products not defined at the WTO. You don't find this definition. You find it only on case law. And these definitions have been broader. At the beginning was about the physical components of the product. So if the two component water, if the component of the water is the same, you can differentiate it. But over the years, and especially one of those cases called asbestos, they realized, well, it's not about the physical components, it's about the consumer perception. Do consumers perceive those products as being different? Do they have a different market space within a country? Do they have competitive? And all those thinking is very present in the last decisions, which indicates that nowadays, not again, we never know for sure, so I can't guarantee, but it will be much easier to defend that an egg comes from a battery cage and an egg comes from a free range are not alike at all, regardless of the end product.
Thank you.
Yeah.
Yeah, thank you so much for that. First question would be, how similar is, and we mentioned the pork products case in California, the Prop 12 case, how similar is the Dormant Commerce Clause analysis about discrimination from one state onto another state to the WTO analysis of a national regulation discriminating between various foreign states? And related to that, when you're trying to craft manner compliant regulations that protect animal welfare, how would countries go about doing that in a way that's compliant with the holding from the sea turtle case And how much do those manner compliance restrictions restrict the substantive ability of those laws to engage in animal welfare protection? How related is the manner to the substantive degree of protection that countries can provide with their regulation?
Okay. I will start with the second question. I think I can answer that question in the abstract. It's exactly that type of analysis that the appellate body and the panel, so the experts are looking. There is one sentence that is the following. What the WTO tries to do is to make sure that trade flows without unnecessary obstacles. And something it's unnecessary if you can reach that same outcome within a different path. So it's about equivalence, it's about reaching. So in some of the cases, what the WTO will try to do is not just to determine the level of protection. That's about the country. So what's the level of protection you want to give for the sea turtles? What's the level that your country wants? That's not what they'd be looking, but whether if the degree, the fulfillment of that can happen through different options. And in some case, the WTO say, well, you can definitely reach, not the WTO, but the arguments provided by the country. So the complaining country will show that, hey, there is a least restricted alternative out there to get to that same. And the defending countries say, well, that might be an alternative, but it doesn't get me to the same level of protection. And that has been upheld by the WTO. For instance, in the case of, if I'm not mistaken, the tuna case, I need to look back at my notes, but the level of protection that the alternative labeling system was lower than the level of protection that the US government labeling system would provide. So it's not about the level. So in that case, your answer is yes. In discussing the manner will be taken into consideration the substance. Yes, they will definitely make sure that even though we are looking at different options, that options deliver the same degree that you are seeking for. Now, in terms of the Prop 12, I'm not a US law expert myself, so I cannot bring all the legal doctrine that goes into in that analysis. But it pretty much caught my attention when I saw, because of the type of questions. It was about extraterritorial effect of a local legislation, and it was about the undue burden in interstate. We use a different vocabulary at the WTO, but pretty much ends to those two type of discussions. So I see a lot of parallels in this. That's why I'm following quite close the developments here in the US. Oh, okay.
Hi, so I was wondering what, if any, alternatives can be done to basically prevent like the discrimination argument? Like, for example, with the turtle case, could they, instead of requiring a different amount of like months or years for each country, can they just provide like more funding to one country to be able to comply faster? Or just like, have there been any cases in which they did something else that was allowed?
I'm not sure if I understood fully your question, but from what I understand, if you can avoid the discrimination, I think if the original case, again, let's remember that just like the WTO cases and legal interpretation have evolved, governmental policies have evolved. So they are much more less, I don't want to use the word bias, but they are less country oriented. So, and by being that way, more blank, more, more across the globe, that's the standard we will implement. That avoids the discrimination, because years ago, decades ago, you would have in that case that we will allow the import of, I don't know, microphones if the policy of the government in whatever country complies with our. So it was the way the original one was made that there was too much differentiation about country A to B. Whether if you just, for instance, establish what's the requirement you want for your microphone, but you're not looking when you justify your measure, you're not looking at different geographical, or if there is geographical consideration. I'm giving another example now. When you stop at the border, the entrance of some products that might be carrying disease, you need to do first a cross-border for all, but if the same, you can allow for one country to products from their country to enter your border, if that same condition applies to the other country. So in this case, that's when you are looking at the other territory, you look at that, but your original measure, I think that's the differentiation that I want to do. Your original measure is not looking at the domestic of other countries. You just say that's here. That's one way you avoid discrimination, but it's very hard to give you a general answer, not looking at the case itself, the provisions itself. But the recommendation I would give to you, if you are advocating for your government, is try to be as much as and again, I'm sorry that I don't find another word in my mind, but trying to be unbiased when you're looking at the recommendations, so you don't target one specific country as in the past was the case.
Thank you.